Hi, Derek here, your helpful Mckenzie friend. Today I'm going to cover your dispute resolution appointment within your child arrangement's family court process. This short video includes what the DRA is, the expectations, and how to get the best possible outcome. It follows on from my fact-finding hearing and abusive allegation videos, which I'd recommend watching. If you haven't done so already, then please hit my subscribe button below and get access to my must-watch videos. Now, the dispute resolution appointment is typically your second hearing in the child arrangements process. The objective of the hearing is to negotiate with the other party in an effort to agree what the outcome of final child arrangement should be, and therefore avoid the need for the final hearing. And if you can't agree, then at least to narrow down the number of issues between you. Now, it is not always possible to agree matters with your ex at this stage, which I get. And more often than not, it's challenging enough just to have even the most basic form of communications with them. And there may even be a non-molestation order in place that prevents any form of direct contact. So, to assist you in getting the best possible outcome, I would strongly recommend that you produce an effective position statement prior to the hearing, and ensure that you provide a copy to the court. It should include a very short background, what current contact is, what you propose for the final contact arrangements, and it should also include a proposal for interim contact. Now that is what contact should be between now and the final hearing, if matters are not agreed at the DRA hearing. Now, if you haven't watched it already, then I suggest you may want to watch my Writing Your Position Statement video, as it explains how to write an effective position statement. And if you'd like a copy of my free position statement template, then simply send an email to me at Derek, D-E-R-E-K, at McKenzieFriendConsultants with an s.co.uk. So, what happens at the hearing? You're expected to be available an hour before the hearing to discuss and negotiate with the other party. If it's an attended meeting, then on arrival, I recommend that you find the court usher and firstly provide him with a copy of your position statement to pass on to the judge. You should also provide a copy at this stage to the other party. You will then find a meeting room for discussions with your ex's barrister if represented, or with them directly if they are not represented. However, I know this is going to be a little tricky. On the other hand, if the DRA is a remote hearing, then the barrister will typically call you an hour or so before the hearing to discuss the case. If you can reach an agreement at this stage, then great. However, that is unlikely in most cases. In the hearing itself, the barrister will normally summarise the positions, anything that has been agreed, and the differences that remain between the two parties. The judge will then turn to you and ask for your view, and you should ask if he has a copy of your position statement to hand. You should refer to your statement and outline your position with regard to final contact. You should also correct any of the barrister's claims if you're in disagreement with them, which you're almost probably going to be. The judge should then discuss the positions between the two parties and try to get the parties to be a little flexible in their respective stands by asking them if they will consider this or consider that. The intent of the judge is to try and find a compromise between the parties, or at least narrow down the number of issues. If with the help of the judge an agreement is made, then great. He will confirm the final order and your court proceedings will end. Perfect. However, if an agreement can't be reached at this stage, then the judge will set a date for the final hearing, or most probably apply for a listing for the first available date after XYZ, which will be in 3 to 4 months' time. He will then discuss the expected length of the final hearing, which is typically a full day. However, it could be as long as 2 to 3 days, depending on the complexity of your case. The judge will also discuss any other requirements for the hearing, such as statements that are needed, witnesses, and reports that may also be required. He will then discuss what the arrangement should be for interim contact. That is, what the contact arrangement should be between now and the final hearing. The two parties will make their proposals for interim contact, and the judge will then make a decision and confirm his position. And that's it. You've got through another big step. The DRA is an extremely important hearing and can be a little daunting, and most people would probably benefit from some experienced assistance. Therefore, if you'd like assistance or simply discuss your case, then go to www.mckenzieFriendConsultants.co.uk and book your free consultancy with me. That's it for today, and if you find my videos helpful, then please hit the subscribe button below. Bye for now, and until my next video.